Welcome to Laid Back Law with your favorite lawyers from around the interwebs, discussing the most pressing of topics every Friday at noon Eastern Time.
All right, we're back for another weekly episode of Laid Back Law, Legal Fridays with, so far, Ian Corzine and Michael Boyer of LawPod Daily. And good that you put LawPod Daily there. You know, actually, Michael, I wanted to ask you about that. Is your channel LawPod Daily or is it Law and Legitimacy?
So the original name was Law and Legitimacy. It evolved out of what were essentially pre-recorded long forms. That's how Norm and I came to know each other, as I discovered one of his first sort of tin canny, terrible quality long form recordings. And Law and Legitimacy was sort of the working title that he had come up with. As the show has evolved, we have gone from just the pre-recorded long forms into live, more long forms. And then we decided at a certain point to just go every single morning for a half hour and see if we couldn't tease out sort of the themes of legitimacy through more topical stories. And so that's the reason for the LawPod Daily. It's just easier. Law and Legitimacy is a super long name. I don't even think it fits. But
no, and it's awkward.
Figure out how to get Rumble to let me change our handle over there. But the green platform, is
Big Green.
The red platform is LawPod Daily, but it's all Law and Legitimacy, baby.
Okay. Well, just so people know that, and there should be links to everybody's channel in the description. If they're not, then I need to get to work. I hope you consider subscribing. I'm going to start this off. Michael, you sent us a public statement from the Connecticut Bar Association.
Yes, I did.
Of all people. And I guess the Connecticut Bar Association is speaking for the whole country. What are they trying to say here?
Well, they're certainly speaking for the Connecticut Bar. I think so. It was 1 week ago they put this out, and I'm sure many of the viewers saw some reference to this in their timelines. But it's a very short statement. Are you able to bring that up for us to look? Oh, you got it. Awesome.
It's right there.
So, I'll just read it verbatim, and then we can talk. But it says, words matter. Reckless words attacking the integrity of our judicial system matter even more. In the wake of the recent trial and conviction of former President Donald Trump, public officials have issued statements claiming that the trial was, quote, sham, a hoax, and rigged. Our justice system is, quote, corrupt and rigged. The judge was corrupt and highly unethical, and the jury was, quote, partisan and, quote, pre-cooked. Others claim the trial was, quote, America's first communist show trial, a reference to historic purges of high-ranking communist officials that were used to eliminate political threats. These claims are unsubstantiated and reckless. Such statements can provoke acts of violence against those serving the public as employees of the judicial branch. Indeed, such statements have resulted in threats to those fulfilling their civic obligations by sitting on the jury, as evidenced by social media postings seeking to identify the names and addresses of the anonymous jurors, and worse, in several cases, urging that the jurors be shot or hanged. As importantly, such statements strike at the very integrity of the third branch of government and sow distrust in the public for courts where it does not belong. To be clear, free speech includes criticism. There is and should be no prohibition on commenting on the decision to bring the prosecution. The prosecution's legal theory and the judge's rulings are the verdict itself. But headlines, grabbing, baseless allegations made by public officials cross the line from criticism to dangerous rhetoric. They have no place in the public discourse.
Okay, but essentially,
the last part is really where I think this is relevant for lawyers.
Okay.
Lawyers obviously have a right to free speech, but under certain circumstances, the ethical rules that govern attorneys constrain the way that we can communicate. One of the easiest to talk about, I'm sure, Ian, you can bring up some examples, but it's attorney advertising and marketing, right? There's very strict ethical guidelines around how you can solicit business to clients as an attorney. So there are certain restraints on the way that attorneys can communicate. So it's often the case that there are bar complaints and certain other proceedings initiated to rule some of that stuff in. But by and large, such a broad and sweeping statement by a bar association as to the nature and character of certain attorney's speech that isn't even ascertained in there, there's just, quotes given but not attributed anywhere, they're made very broadly, is sort of chilling for those members of the bar who swear an oath to uphold the Constitution. And to the extent the Bar Association is represented by a group of people, I don't know, what are they, 8 or 9 strong, I think, on that association. It struck me as a little odd that we're, they speak for all the attorneys, but it's almost like an implied warning that, with what effect, right? So wanted to bring that up because I think it's a great way to get a Friday kicked off.
What I interpret that as, really quickly, and I definitely jump in after it, Ian, is they're implying this term, which is one of my most hated phrases out there, or terms, stochastic terrorism. That's literally what they're writing in there, is that people might also call this dog whistle. They're saying that what's happening here is you're allowing people to get a message out to the other people who are going to be deplorable and do deplorable things if you allow this to stand. Meanwhile, ignoring the fact that they're trying to be Big Brother and crush any kind of dissent whatsoever. Anyway, let's go ahead, Ian. Sorry.
Eric, I completely agree. Whether you characterize it using that phrase, which is hard to pronounce, or you just characterize it as speaking in both sides of their mouth, they're trying to get some sort of credit for free speech. It seems like that's the common thread for a lot of these advocates that actually want to restrain speech and limit it unduly and against the law. They come out with, I'm all for free speech. And what's so funny was Michael read it, but they use but right there in that phrase. And they really fail to take into account a number of different issues. And that is, a lot of our formalistic views towards lawyer speech, were passed and enacted and written back in the 50s, the 60s, the 70s, when there was a different kind of, well, first of all, we didn't have the platform that we have these days where you can go on these shows and talk all day long, but also it hasn't taken into account, our current vernacular and the words that we use to describe certain things. So yes, there is restraints on lawyer speech when it comes to solicitation. And additionally, we are obligated generally not to, I always characterize it as not to be reckless in public with our public statements. So we certainly can criticize judges and jurors and witnesses and just people that are in the public eye. We just can't be reckless about it generally. And then we're going to be subject to an ethical complaint. So it's not even if we did, it's not like we're going to jail or something. It's just that we're subject to discipline in our area of our practice. So the point of this whole thing is absolute BS. In my opinion, it is an absolute message to the bar and certainly bars across the country that we should limit our speech, and that they're going to be watching, and there are going to be some ethics complaints coming forward for people who step out of line according to their views. So I think it's a great issue to bring it up. And I think that it's just further evidence of how we're, continuing to censor ourselves. And censorship, we should talk about after this, is a larger issue because it's getting ridiculous how we have to self-censor ourselves when we're online. So anyway, I don't want to go into too much.
Not that I would ever do that on this fine red platform. Not would I ever use special words to talk about things like beer bugs and grapes and hot shots and graping. You never know, because you go out and pick some grapes and get some wine. A lot of wine coming from the platform for sure. By the way, but you do know what "but" stands for, right?
What does it stand for?
According to Mark McClish, trademark statement analysis, "but" means behold the underlying truth. And it fits perfectly on.
What's the second T for? I'm just kidding. So over on Law Pod Daily, we often talk about this concept of false authentication, or authentication of false narratives through the judiciary, right? So what strikes me about this bar message is sort of the resemblance to what we saw with the push to have Trump removed from ballots in various states earlier this year. Many of us sort of forget that. It sort of faded into the background, but recall the Colorado Secretary of State was sued by an NGO. And that lawsuit is what initiated and catalyzed sort of that domino effect of Maine and I think one other state at least. But the lawsuit itself was very, very long. I mean, it was a voluminous filing. If you went and actually read any part of the complaint, you realize that what the plaintiffs were doing in that instance was actually trying to use the judiciary as a clearinghouse to call whatever made it into the public record the truth. And what they were using were the results of the January 6th commission and that report, right?
Mhm.
And so if you trace back to think through the I guess the composition of the January 6th committee, there's a colorable argument that it was improperly and unlawfully constituted, that there weren't enough members, that certain members that were selected by the opposite House, Republican versus Democrat, were actually stricken and not allowed to be on that. I think there were only 5 members, and yet they produced this really long report, came to very sweeping conclusions and I think that there's been a lot in the House Intelligence Committee lately about what actually did not make it into the report and what was deleted and stuff like that. This is astounding to me coming from a bar association because, and someone in the chat said this, apologize for getting it. It was like Kevin B or something. The use of terms unsubstantiated, right? And these characterizations as baseless and stuff like that, that is really the hot button part of this entire message, right? Not only that you're trying to sort of terraform and curtail attorney speech, but also that you're using a very established mechanism by sort of NGOs and partisan groups as against Trump, right, to kind of use your status as an institution to sway the historical perspective on events that are highly, highly, highly debated among average people right now, right? You're saying that history went this way unequivocally. It's unsubstantiated. It's baseless, right? And then basing your conclusion, like you said, sort of that stochastic terrorism angle, but then you're using that as the bludgeon to say, so if you suggest that any of this stuff is anything other than this, you're a liar, right? And you're anti-American and you're threatening the integrity of our institutions and our judiciary, right?
Totally agree. But I'm going to push back on one thing, or just in case devil's advocate is needed at all. Should there be a Goldwater rule for lawyers? And I don't know if you know what I'm talking about with the Goldwater rule, but that is when he was running, Barry Goldwater was running against LBJ, they had a publicity campaign where they had psychiatrists come out and diagnose Barry Goldwater as being crazy. And ultimately that led to a rule, and I don't know if it's AMA or whoever, but essentially you are not allowed to diagnose somebody unless they are your patient on television. I think it's US only. I think other countries can do it, but is there an argument to be made about lawyers diagnosing particular things or making claims? I'm just curious.
Certainly, Ian, if you want to take the lead,
sure.
I had to defer.
Yeah, I mean, there is a concern to the lawyer himself about acquiring clients by virtue of his statements or her statements. So there's that, but there should be absolutely no rule banning commentary. We're getting too far afield of what the ultimate issues are. You know, a lot of what was referenced in the statement and also what's referenced in a lot of the headlines today is dangerous communications. And in my opinion, subject to a few, in my opinion, just 2 exceptions, there are no such things as dangerous communications. And frankly, I believe that lawyers have the ability to make dangerous communications themselves. They can't make reckless, they can't cause harm in their statement, imminent harm, in their statements. But they can make whatever claims they want. This is part of the marketplace of ideas. So I do not think that there should ever be a rule that says that I can't give my opinions because I'm illegally trained about some issue or about some person's credibility because that I need to have more facts or something. I need to know the person or have them be a client. No, I can say whatever the heck I want to say, subject to causing imminent harm to someone. So. I don't think the Goldwater rule should ever apply. Frankly, I disagree with it back then.
Well, and I think that inevitably you will run into a situation. So that the article references certain words in particular, right? Sham, hoax, corrupt, that sort of thing. I think in the particular case of the word sham, I mean, there are statutes all over the country, civil statutes all over the country, especially with respect to sort of corporate operations. North Carolina has a corporate sham theory of legal liability, right, on the books. And it's often the case that attorneys in their representation of clients and their prosecution of claims in the courts have to speak in a manner that will be proven, in the forthcoming trial, in the lawsuit itself. So there's an inherent level of risk taking in good faith, right? You have a duty of candor toward the tribunal, right? You have a duty to act in good faith. You have a duty to act ethically as per your state's code of conduct, etc. However, you also have a duty for zealous advocacy on behalf of your client, right? So attorneys are trained as a matter of course, and as practitioners, to zealously advocate. Really, the limitations on speech outside of sort of the marketing and solicitation stuff is talking about active cases in which an attorney represents a client that is ongoing, and really when it's in the public eye, right? Norm is probably one of the best to talk to about this because he has higher profile cases that he's worked on. Being in front of a camera can be dangerous for an attorney because it can prejudice the interests of your clients, because your duty is first and foremost to the client. So I think that my real issue with this is that it's using a lot of vague and broad terminology. It's asking attorneys to actually sort of dull or otherwise dilute their instincts for advocacy and to look at the facts. And it's also assuming that attorneys are incapable of saying those words with the sort of intentionality or in an unsubstantiated way, as if they were just, non-attorneys or civilians making, baseless accusations about things that they have no knowledge of. I mean, if anybody is able to use those terms in a way that is more productive than not, it's those that have access to public court filings and can actually read and understand exactly the framework of the law that's being applied and as applied to whatever fact pattern, right? And in the case of Trump, it's obvious to us.
Does this slide into defamation at all? Because I feel like we're starting to get into that question. When you mentioned sham, well, sham is kind of a vague term. So I could say that's a sham, that's scammy, that's weird, and I don't know if that'd be a problem. But if I did say that a corporation was committing a specific crime, then that would now get into a defamation territory. Or somebody correct me if I'm wrong. I think Nate's correcting me as saying racism. Calling somebody a racist apparently is a free-for-all, and you get to say that's my opinion. And even though there's no factual basis for it or whatever, you can smear somebody with that brush, and it's not factual. So anybody want to jump on that?
I mean, I'm just going to say a few things. You're exactly on the right track. It does veer into defamation, and that's not protected by the First Amendment. But at the same point in time, that's a civil cause of action. And those are short of some of the defamation per se, delineations in state law. You have to prove that you can fight a lawsuit that someone says you are, I'm trying to use the word, subject to racism or something. You can fight that in a civil courtroom via a defamation case. So yeah, I mean, that's a limitation on our speech, but we can't defame someone. You can't say something that's not true that causes damage to their reputation.
Is there a criminal defamation?
I haven't seen one.
What if somebody becomes harmed?
In Louisiana, there is. In Louisiana,
oh, okay. I was going to say, I would wonder what if somebody said something about a person, claiming that they're a PDF file or something, and then that person gets harmed by others. Could there be a liability from the first person defaming or smearing that person and causing harm on the other? I don't know. I'm just throwing out a question.
I've not seen criminal defamation before. So Nate, I don't know if you have more information on that, but
yeah, I've not seen it. Like in New York, adultery is still on the books as being illegal, but it's not enforceable because of the Supreme Court precedent. You can't enforce adultery. But I know in Louisiana, defamation is a criminal offense. I think it's a misdemeanor, but I'm not sure how often it's enforced or whatever.
Okay. What about the scenario?
There's also other criminal statutes that would cover the same conduct, same fact pattern, and would be more likely to be prosecuted that way, right? So I don't know that defamation is really going to be your best argument. Like, oh, they defamed me and then I got hurt, right? I think there's probably something else there.
All right. Well, I'm going to shift now because we've got Phil with us, and probably for a limited amount of time. And as everybody knows, right now, Georgia is becoming the cesspool of all legal things, because we're going to talk about Fulton County with the Young Thug trial, but then we can't forget Douglas County, who has their own problems. And since we have Phil on here, and we got Nate on here because Nate released a great video on the Douglas County judge, which is a follow-up video. Let's start with Woody, I guess, Phil, and the YSL trial.
But hold on, before you start, Phil, I just think it's fabulous that Phil knows more about Littlewood, Woody, and YSL than I do. How are we living in this world, Phil? How are we living in this world?
Nate, look, Nate, you're in New York, and I'm a little closer to the action, but that Woody, he's brand new on the scene, right? I mean, I didn't really see him coming, and then right out of nowhere, he becomes not, kind of the center of attention, although it's shifted, but. He's been taken to social media like a madman, and he's like posting pictures, just chilling in the pool and all this kind of stuff. It's almost like he doesn't even care one bit in the world, Nate, what he's doing in this trial.
He's gangster, right?
Well, he is, but all right. So we can talk about Woody as much as y'all want to, but the big thing is, it was announced today that there's not going to be any jury proceedings in that young fellow case. And by the way, I'm traveling. I'm on the way to the Fortress of Solitude, so that's why this background behind me is not what you're accustomed to seeing. And I'm sorry about the lighting, but anyway, it'll do.
Oh, you're fine.
But Judge Glanville announced there's not going to be any proceedings at least not with a jury for the next couple of weeks. And I think he probably is halfway expecting, or maybe fully expecting, as I am, the Georgia Supreme Court may drop the hammer and drop a stay on that trial, because there's been a couple of now 3 or 4 motions to recuse Judge Glanville. And I've done some streams on this on my channel for those of you who might have seen it. And I've even cut some of them down to bite size, 30-minute segments if you want to check them out. But the bottom line is this: the judge is stubbornly denying to recuse himself. But even before that, the first thing a judge has to do in Georgia, if a properly filed motion to recuse has been received, the judge can't really go any further than assessing whether it was properly filed. It's got to have an affidavit that supports facts, which, assuming they were true, and for purposes of his initial review, he must assume them to be true, that things that are, if true, if they would give rise to sort of a reasonable person believing that the judge was biased, then what has to happen under Georgia procedure is another judge has to come in and rule on this. So the allegations are based on judicial misconduct. It's alleged that not even alleged, the judge concedes it. He had this ex parte, one-sided meeting back in his chambers with the prosecutor and with Woody and Woody's lawyer, and apparently some deputies and other security personnel and a court reporter. A bunch of people were back there. And then they were talking about Woody's testimony. And this is after Woody had started testifying. Ex parte, for the non-lawyers watching the stream, that's a bad word. And, judges can lose their job for it. And they have lost their job for less than this. So they've accused him of some very significant judicial misconduct. That he absolutely was wrong in denying these motions to recuse summarily. He should have sent them to another judge. He should have stopped the proceedings as the statute requires in Georgia. But because he stubbornly is refusing to do that, he's basically denying. In other words, he's saying, look, you guys are filing this motion to recuse me because you don't like my rulings, and that's not a sufficient basis. And if that's what we're going on, the judge would be right. But that's not what's going on. They are wanting to recuse him for judicial misconduct, for his actions in conducting this illegal ex parte proceeding. And so now they dropped yesterday because they ran out of options. Okay, if the judge refuses to do the right thing, what are you going to do? They've made an emergency appeal to the Georgia Supreme Court to stay the proceedings and it's called a mandamus action. They want the court to mandate that he follow the law and have another judge weigh in on this. But here's the thing, guys. He's the chief judge. So if he sends it to another judge in Fulton County, it's going to be one of the subordinate judges, which raises the question, shouldn't you really bring in an outside judge from another county to weigh in on this? And that's what I think should happen. So I think that the Supreme Court is going to put the brakes on this trial for a minute, so that this can be all sorted out, because Glanville's position is like, look, if I'm wrong, the Court of Appeals will tell us, after the trial. But that could be in 2032 at this rate, while people are serving, potentially life sentences. So if you've got a case that's so far gone and to the point where it's just an unfair trial, then it really doesn't make sense to wait 5, 6, 8, or 10 years, for any appellate review of what I think is a judicial rulings that have just gone amok. This case is so far beyond, it's just irredeemable in my view at this point. And I think we're about to see the Georgia Supreme Court step in. So there you have it. There's your
Phil,
case update in a nutshell.
2 questions. Like, one, can you confirm this? I have heard that lead attorney has stated that Glanville was seen as kind of a decent judge, like a middle of the road, not crazy, not off his rails, or off his rocker type of judge. Have you appeared in front of him? And isn't this behavior very weird?
The behavior is, it's. I don't know if I would use the word weird, but we are definitely in legal la-la land here. We are in uncharted territory. It seems to me that he's like, because this case has been going on, it took him a year to pick a jury. They put a lot of work in. If he were to, grant this motion, and they've actually asked for a mistrial, which ought to have been granted too. But for him to do that at this point is for him to just say, look, he would have to admit that he's botched it so bad that all of that work is out the window, and probably double jeopardy would prevent these people from having another trial. And I have not even addressed whether or not these people may or may not be guilty, because that's not the point. But let's say they might be. If he were to do this, then some people will say, he's let killers go free or whatever. But for him to do what I think is the right thing to do, he would also be admitting that he screwed it up so bad and it's now beyond repair. He's got a long and otherwise, remarkable career on the bench. He's brigadier general in the Army. He served on active duty and in overseas. I think it was in Afghanistan, maybe Iraq as well. I'm not sure, but as a military judge, right? And so he's got a pretty impressive pedigree, so to speak. And so I just don't know what's happened with this case, but I do think you got a lot of stress. You got a lot of big personalities, his included, clashing with some really fierce advocates. They're all doing a fantastic job, but just look at Brian Steele, who was willing to go to jail in order to engage in the advocacy that was required for his client. And so these lawyers, they're not just people that are going to just back down.
Is that part of the problem, Phil? I was in the Army. I think you were Navy, right?
Yes.
His actions to me felt like a general who is used to just saying whatever the F they want to happen and people deal with it, versus the rules. The rules can be bent a little bit. I'm a general, do it, do this. And is he letting that kind of mentality leak over into public court?
And that's an interesting observation. I've heard a lot of other people comment similarly, Eric. And but if you watch what's going on, normally when we have a hearing, the judges, if they make a ruling or make a point and you say, Judge, can I be heard on that? And they say yes, then the judge lets you, make your case. They let you finish your sentences and finish your thoughts, finish your argument. But what he does is, before anybody can actually finish making their case, he will interrupt them, and he won't let them finish. He goes, I get all that, but if I'm wrong, the Court of Appeals will sort it out. Is there anything else? And I'm like, you got to let them finish, because
is that deliberate though?
Is
he saying that? Or okay, I'm going to ask this as a non-lawyer. Is what he is doing actually preventing them from getting their statements on record? And if it's not on record, it can't be appealed.
So there is some of that, and that's why you see these very loquacious motions that are being filed. I've known Brian Steele, for example, for at least 25 years, and my first dealings with him was when I was a prosecutor and he was on the other side of the case. And let me tell you, he wore me out with really creative pretrial motions, and I'm like, that's good advocacy right there. It kind of, it was a little bit annoying because I'm like, oh my God, he's actually, making me work, but that's okay. But he's a good advocate, and he uses a lot of words, but his pleadings were even wordier than normal. And so the same is true for the other attorneys. The mandamus action that came out yesterday is 80 something pages long. I haven't even finished reading it. But they're putting a lot of these things in writing because they may not be able to get them on the record in the courtroom, if that makes sense.
Sure. Nate, you're muted.
One of the things I found crazy about this case is the mistrial aspect of it. You have a witness who takes the stand, who's sworn in, takes the stand. So that generally means, that has to happen. You can't have ex parte communications because he's literally testifying, right? He came off the stand one day. The judge then says, the judge, the prosecutor, and all these people take this witness into chambers, ex parte, threaten him, right? If you don't testify,
he pulls out the statute on perjury and reads it and says, I can keep you in jail, not till just this trial's over, but for all 28 defendants, the remainder of whom are not on trial yet. And Woody's saying, oh, if you're going to keep me in jail till, indefinitely, then all right, then I'll testify. But he also said, everything I'm going to say is going to be a lie.
It's a lie. Yeah. Like, did he say he was going to testify? He killed these people. And they were like, we'll prosecute for you for that. But then he said, if I say this guy killed them, they're like, oh, we won't prosecute you for that. It's like,
and so now we lawyers realize that, okay, this is now Brady material. He's made these statements. That's all Brady material. The judge is now a witness to these statements. The judge is a witness in the trial now, whether he recognizes it or not. He is a witness, and so are the prosecutors. They all have conflicts of interest now. They can't be, the prosecutors, in my view, can't continue on, and neither can the judge. But hey, that's just my opinion. What do I know?
For the audience, what Brady, can just somebody just let the audience know what Brady material is? Because we've mentioned it a couple of times.
Yeah, you do it. You got it.
Well, Brady material is any evidence that would tend to show that the defendant is innocent or not guilty of this particular action. So in this case, you have a witness in the judge's chambers that is saying, I killed these people, I did that. That would tend to show the defendant is not guilty of these charges. So that's what we call Brady material. Now, Brady material is very important because if you hide, well, number one, it's unethical to hide Brady material. You can lose your law license if you're a prosecutor if you hide Brady material. And now, like Phyllis said eloquently, the judge, the prosecutors, everybody in that room is now aware of it, except for the defense attorney. So
can't you get locked up for it, Nate? Didn't Nifong get locked up for it? The one in Duke Lacrosse guy?
Lacrosse, yeah, the Duke Lacrosse, he got locked up for withholding.
Yeah, he hit it right. He hit a whole bunch of Brady, but see, his conduct rose to the point. I mean, there is no crime per se for not turning over Brady material, but Nifong went so far. And let's face it, you could make the case that now Glanville's in that territory, but Nifong went so far.
Textbook territory, right? Mike Nifong is like, that's Duke. That's, I grew up in North Carolina. I remember when the Duke Lacrosse trial was on TV, right? I was very young. I remember that. And then I met Mike Nifong again via textbook in my legal ethics class in law school, right? So Glanville's in textbook territory is what I would say, Bill.
Yeah. I mean, it's bad. I mean, the thing that I don't really can't get my brain wrapped around is every lawyer that I've talked to, it's unanimous in the legal community that he screwed up, that he screwed up really bad. But it's almost, but like, why can't he's got to see it. Either that or he's in denial. I just can't understand.
But, I was going to ask you, Phil, your opinion, being there. Is there any good faith way to construe what Judge Glenville did? I mean, I was trying in my head, I was like, just put aside all the things that we can attack him for, but is there any way we could find a route that he's trying to do his best, or is he crooked?
So I've gone through, on one of my recent streams, I went through and I looked at, okay, the rules in Georgia. So the general rule is that ex parte is bad and judges shall not do it. There are some limited exceptions. For example, scheduling. If you want to contact the judge to schedule a plea or something else, there are some limited exceptions. Or like if you apply for an arrest warrant, that's technically ex parte, or the temporary protective order. If a spouse is beating up a spouse, you can run to the courthouse, get an ex parte stay away restraining order, but you got to come back in 30 days. And for that one, it can't be ex parte. So there are some limited exceptions, none of which apply to meeting with the prosecutor while the trial is underway with a witness who's already been sworn.
Yeah.
There's no exception that covers this. None.
Phil, you actually gave a perfect segue to a decision that just happened today.
I did.
And the Supreme Court ruled 8-1 upholding the gun ban for those under domestic violence restraining orders. And on the surface, this sounds like, yeah, of course, right? Except, is this really constitutional? I find it odd because a restraining order, which I've covered lately because of the Fiona Harvey stuff, from what I understand, a restraining order is not a conviction.
No. Well, if you read that ruling, what Chief Justice Roberts, who wrote it, he said that we can constitutionally keep people from having or possessing guns while the order is in effect.
Why?
Yeah, and I don't think it went. I don't think it went any further than that. But to your point, Eric, of whether or not it's constitutional. Look, the Constitution means what the Supreme Court says it means, so I guess it is constitutional now. I kind of thought that case might have gone the other way, but hey, I mean, they're the ones creating the papers.
Well, I think it all depends on, because some people think due process, there's only one type of due process, that you're going through a full trial, and there are multiple levels of due process. The most light due process you can have is called notice and opportunity to be heard. That's usually for tickets. So that's actually due process. They give you notice, your opportunity to be heard, and they can say, well, we don't believe you, so then something negative happened to you. Also, what's also known as due process, a lot of people don't know, is going to vote for your representative stuff. That's also another form of due process, but that's an aggregate due process. That's for a group, not just for individuals. So what we're talking about here is that the Supreme Court is saying the due process, you can't lose your rights unless you have due process. Due process is the standard in which you can remove somebody's rights. And the due process that's here is they're saying is that the restraining order, there's due process in that, and while that and since you've gotten some type of process there, then they can temporarily hold these rights because they've afforded you due process in that way.
What bothers me about that, though, is I find it similar to no-fly lists, which people are just put on because it's determined that they're this or that. And now I don't know how many of you guys have dealt with family law, but there's a lot of cases where restraining orders and different things are gathered, and they may be true or not true. There's a lot of heated emotions going both ways, and I just kind of worry about this.
Well, so it seems like what you're getting at is something. I don't want to call it extrajudicial, but I think it's quite difficult for the court in this context to get at sort of the cultural zeitgeist that you're describing, right? Because you're not saying something that is different from the concept of divorce, right? And custody awards for women on average, mothers on average over the fathers, et cetera. I think what you're referring to is sort of the relative ease, the perceived ease with which a restraining order can be issued, or sort of these divorce awards, custody awards can be found, right? Or the slant that the justice system takes. I think you've got the Me Too movement as a cultural force, the same way that you had Mad and Sad years ago for drunk driving, and sort of the way the criminal justice system evolved to punish very harshly DUI arrests and stuff like that. But it's very difficult, I think, to your point, Nate, when someone has been given some form of due process, right, for the court to look beyond what is in writing, what is within the four corners of the lawsuit, to say, yeah, the cultural zeitgeist makes this a specific case where we're going to, that's not what the court is supposed to do, right? Ultimately, that's a ground up change. respectfully, I think that that's kind of where that's the tension I think that you're seeing, right? Is that domestic violence restraining orders are a way for someone's Second Amendment rights to be restrained, right? And it's pretty easy for those domestic violence restraining orders to be issued, and the due process is perceived en masse to be very thin by comparison to what people would normally expect for themselves. Right?
There's also the other problem that restraining orders often have the opposite effect of what is intended. There are countless cases where the restraining order became like the final straw that caused somebody to snap, if you will.
Yeah, but I don't think you can work with the minority of incidents over the majority, because I know when I was a prosecutor, restraining orders, anytime you had a DV case, a restraining order was automatic. It was, here comes a DV victim, here's the restraining order. And I do understand, and I am very sympathetic to the fact of I am automatic removing someone's rights because of a restraining order, especially in that type of scenario. I think for all of the rights, you need to be convicted, right? For your freedom, for everything else.
What I thought.
So when you're talking about, I think Justice Thomas says it best, is like the Second Amendment is like the disfavored right, because you're allowed that to be removed without as high a bar as something like your First Amendment right, or even your freedom of movement. So I think that would be the argument. But the Supreme Court says 8-1, it's obviously got to be disfavored because you can remove it without this full conviction under the normal due process.
This ruling, before I go, let me point this out. This ruling leaves out there's a big class of these restraining orders. So in many states, I know, like in Georgia, where I am, for example, the first step, you go down and get you what's called an ex parte restraining order, and it's valid for up at the most 30 days. And then there's a right to a full hearing and an opportunity to present your case and be represented by a lawyer and all this. But what we've seen happen is somebody runs down to the courthouse, says, oh, my spouse is beating me, and they get this restraining order, and they say, oh, by the way, he's got guns in the house. And so what they'll do, without any notice or an opportunity for the person to be heard, and by the way, the spouse could be lying about all this because we haven't had a hearing, but the judge on the temporary restraining order, which is just good for a short period of time, the sheriff shall seize whatever guns are in the house. So imagine you're just somebody sitting at home one day, and let's say your spouse is trying to get the upper hand in the divorce that they're getting ready to file so they can get the kids and everything. They make this claim, and next thing you know, you got sheriff's deputies saying, we're here to take your guns away from you, right? Well, right. I'll be honest with you, a lot of law enforcement officers are very uncomfortable with that because, first and foremost, they don't want to just show up and take somebody's guns because it could obviously go wrong. But this person has had no notice. They've had no opportunity to have a court hearing before not only their right to own them, but literally to possess property that they already own is being judicially taken away with no due process. Now, that's an open question. We can leave it there for y'all to discuss because I'm about to have to run. But this case from the Supreme Court today does not address that situation, and that's the one that I'm waiting on.
And I'm troubled by it too because, okay, let's say this restraining order is filed, and then they go and take somebody's guns, and God knows how long this goes on, back and forth with disputes, what have you. It could be a restraining order for a couple of years, and then what? At the end, they get the guns back. It's no harm, no foul, but they've been harmed. Technically, they have been harmed without an actual conviction.
Eric, you're in like your 1L doctrinal year right now, my man. This is exactly like the criminal.
Yeah, Eric's going to breeze through his first year.
No, this is perfect. To me, I had the same. So I grew up with law enforcement on both sides of my family. And so when I got to law school and was introduced to criminal procedure, as it were, I had a lifetime of interactions with law enforcement and had a lot of very pragmatic sort of subject matter understanding from a lot of that experience. And I had a very difficult time reading the static nature of these cases and the way that courts interpreted, due process, fruit of the poisonous tree, purging the taint, all of these various things, because I had the same recognition that the way that and Phil, you were just highlighting this in terms of practically how these things happen in the state of Georgia, right? With domestic violence restraining orders, and then the fact that guns would be taken away even before there really is true due process on the merits there, right? There hasn't been an opportunity to be heard, right? A lot of that seizure of one's, liberty and property interests is, you don't get that time back, right? That interaction with law enforcement or your ability to make yourself whole doesn't come by way of the justice system on the criminal side. It's ostensibly coming from the civil side, which also costs more time and more resources and more money. That is the system that we live in, though, right? That is the American justice system as it is right now.
You're right, Michael. Excellent points. And I'm going to have to run now, but Eric and Ian and Nate and Michael, you guys carry on. It's been a great conversation. Thanks for letting me join you for a little bit.
Sure, man. Have fun on your trip.
Oh, and by the way, you folks in the chat, this is a great chat. These are very engaged, and you can tell people here, they're making some excellent points. I love this chat.
Awesome. Yep. They're smarter than I am, that's for sure.
Boo the chat. Boo the chat.
Nate, you hold down the fort. I'll see you, buddy.
Later, Phil.
All right. Thank you. Anyway, I just, on its face, it seems to be a weird decision, but I guess they win, whatever.
Yeah, it's sort of a bell curve analysis, right? And I totally get it. And just to sort of take it from Nate's perspective, right? I'm sympathetic to that intuition that, anytime you're not made whole just because you prove yourself right over a couple of year period or whatever else, right? That you're innocent or you establish your innocence, et cetera, right? There's some get back that one would want, right? And especially when things are slanted. But
and Michael, the other thing too to remember too is that this, in my opinion, it's a states' rights issue. I mean, as Nate said really well, the Second Amendment is a disfavored right. There's lots of things that can disqualify you from owning a gun, whether it be.
Think about Bruin, right? Bruin struck down the New York stuff.
Absolutely. I'm thinking about the Hunter Biden case just recently with their conviction. So there's lots of things. And so this is a situation where I think the court doesn't want to get too inserted in states' dialogue, their ability to organize and control crime. I got to tell you, from my experience as a prosecutor, and I'm a little jaded, a lot of domestic restraining orders precipitated or was before domestic violence. And a lot of times I think the state's just trying to use numbers and say it's more likely that harm will occur
I have a question
if weapons
for you on
are legally there. So
what if the spouse is a cop?
What if the spouse is a cop?
Well, they here, if there's any allegation, in New York, if there were any allegations of domestic violence, they take your weapon away. That's the first thing, because there was a rash of cases in which cops would be, accused, and next thing you know, they're shooting the person, and all thing is breaking loose. So even at my department, we had one guy who actually that happened. So they now just take it away. If any allegation, they take it away. There's essentially no due process in it. Somebody says this happened, they're taking your gun away.
Okay, well, are you on administrative leave, or
you still
get paid?
You still get paid until
you're getting harmed again. You're getting harmed, and that's
they don't consider it to be harmed because they're still paying you. You're still working. It's just they're saying we're taking that tool from you, and you can do other things. So it's like a modified duty scenario.
Yeah, and that cost benefit analysis is pretty easy for police departments these days as well, Eric. Right, the negative PR stemming from a law enforcement officer, wielding a gun against a romantic partner or a spouse or whatever is just not something that you want to play with at all.
I understand, but I'm just pointing this out because you can also have with a soldier. Now, technically, I don't know if they're going to be armed or not, depending on their jobs. But I always wonder, like what the husband runs a gun range. Anyway, these get to be interesting questions that on the surface sounds great. Oh, this is somebody who's involved in DV. Allegedly, yeah, take him away. Forget about it. So let's go and change gears. Phil already left, but I know Nate did an entire video on this particular judge. And this judge, she's a winner. She's a winner. Let's talk about, what is it, Christina Peterson.
They're the second judge from Georgia, right?
Yeah, Christina Peterson. Now, this judge, wow, these people are crazy. I cannot understand how it is that they double down, triple down, and go forward. Another example would be Tiffany Tinyard. This seems to be the same type of mentality and behavior.
And isn't she the highest paid judge or even civil servant
in Georgia?
Yeah. So the way it worked out is that So she was elected to be a probate judge. Now, probate judges for supposed to handle wills and marriage licenses and things of that nature. Now, they are generally the lowest of the totem pole because probate court doesn't really have a lot of trials. Probate judges don't really go through a lot of trials. For instance, they were showing how a probate court judge gets like 600 trials a year or 600 cases a year versus like a criminal court judge that gets like 10,000 cases a year. So when she got in, she was getting paid something like, the probate court judge would get something like $93,000 a year, where a criminal court judge would get $170,000 a year because you're handling 10,000 cases versus 600. So when she came in, she said, well, the only reason why I'm being paid less is not because I'm doing less work. It's because I'm Black and I'm a woman. I'm the first Black woman. So they're not paying me what they're paying the white men who are sitting there handling 13,000 cases. And we all have the same qualifications. We're all attorneys. So the city council said, well, you know what? You're right. We're going to raise your pay. And it happened that they raised her pay to now this rookie judge is now is the highest paid judge in the state of Georgia, even higher paid than the judges on the state Supreme Court. So,
But she's the smartest, bestest judge ever, Nate. She deserves it.
For her first day of the job, but then we have because then you had the allegations. So while she was a judge, but she was actually representing. She had some beef with her homeowners association, so she started representing the other residents in the homeowners against the homeowners association. They settled for $70,000. And the judge, who was essentially their lawyer, kept the $70,000 and never turned it over to the clients. So that was like another thing. Like, hold on, what happened to all these people's money? Why didn't you turn over their money? Then the judge.
Now Nate, isn't that the one thing that burns lawyers? Like lawyers can get caught with drugs and other things, but stealing money from a client, isn't that like the biggest sin a lawyer can ever do and get disbarred?
Well, that's one of the biggest sins, but yes, taking the client's money, not giving them their fair share is something that definitely would lose your license. But there's so much more. Like she locked somebody up because they were in an interracial relationship. Like this is
tell us about that one. That's one of my favorites. Because she does not like Asians dating Black males.
Yes. So essentially, there was this Asian woman who married a Black man, and she went and she didn't know who her father was. So when she filled out the marriage certificate, so she put her uncle's name there. But after like 3 years after they were married, her mother was like, "Hey, this is who your father, this is who your father's name is." So she's like, "Oh, okay." So she didn't have to really do anything because she already had a marriage license, but she wanted to clear the record up. So she said, "I'm going to go and amend my marriage license since now I know who my father's real name is." So she went to the judge, and the judge, seeing this Black man with this Asian woman, said, "No, well, you know what? You defrauded the court. I'm holding you in contempt, and you're going to go to jail for 20 days and a $500 fine because you've taken a Black man off the market." So threw her in jail. So she had to stay in jail for 2 days until they got enough money to bond her out.
And that was for her trying to correct the record, for her to be honest. So the person saying, "Oh, I found out who my father's name is. Let me correct the record," which is kind of an honorable thing to do. Wow.
Yeah. So they were like, "Yeah, we want to make sure that this poor Asian woman, went, got punished for." For essentially doing the right thing. Matter of fact, because people are, whenever I do videos on, I do videos on corrupt white judges, corrupt Black judges. Whenever I do say something about a corrupt Black female judge, I'm a misogynist, racist, secret white man. So what I like to do now, I'll play you guys an actual Black woman. That's right. I'm going to play you guys an actual Black woman who explains the situation just as well as I do.
Imbecile who cannot manage their misery. Why would you, as a judge, you're a probate judge, like you shuffle papers and be like, yes, no, it's not that serious. It's not. This woman submits an amendment to her marriage license because at the time of the nuptials, she's like, I didn't know who my daddy was. It's discovered later. Oh, okay. So, the person who is her dad, who she thought was her dad, not her dad. So she's like, oh, okay, well, in good faith, wanting the record to reflect the accuracy of who her dad biologically is now that she knows. Something as simple, well, oh, okay, well, let's just go down to the court, amend the marriage license. No big deal, you would think. But the allegation is because Queen of Ratchetang, Christina right here, she got an issue.
What is it, a ratcheting?
Being with someone non-Black, she's gonna make this woman pay because you took one of ours. You took one of the good ones. See, if she had joy in her heart and she was just content with who she was, and if she was a professional and a judge trying to just enact the law with no partiality, this would have been something as simple like, oh, okay, no big deal. I get it. All right, good. Here you go. No, she put this woman in jail.
Oh, no, she didn't. Oh, no, you didn't. How you gonna walk up into my courtroom with a brother on your arms? Oh, honey, I don't think so. I am going to give you the hammer in more ways than one. I'm going to teach you a lesson in more ways than one, that you don't come up in here and take our good brothers. You don't. No. I'm going to jail your ass. I'm going to lock your ass up. Is exactly what I'm going to do. I'm going to lock you up because you's a disrespectful girl coming up here and taking one of our brothers when I ain't got no man. How dare you? Oh, no. So that's probably how the judge was feeling when that girl walked in with her husband. That's how she was feeling. Oh, no. I'm going to teach you a lesson, right? You can't walk up into no Black woman domain and not expect to have some kind of drama. Okay? No, we're going to handle you, girl. We're going to handle you. You and your husband. I'm going to lock you up and see if he can bail you out. Wow.
What's in a ratcheting?
Her ratcheting is her version of ratchet. So if a Black woman who's ratchet, she calls it a ratchetang, a wild. So that's her Tiffany Hinyard thing too. She's a ratchet.
Experience. That's all.
She actually defines it earlier on. She defines what her ratcheting is.
Yeah, I agree with this. I wish she was on the panel. Oh my Lord.
That was amazing.
Okay, but hold on. This is the best part. The story doesn't end there.
Oh, no.
No, because she got voted out for incompetence, I believe, by the state. So please continue, Nate. This is a saga.
So eventually they find her because there's obviously issues with the money, issues with her docket, there's issues all over the place. So they eventually say that she's just systematically incompetent, systemic incompetence. So they give the recommendation to remove her immediately. And the voters are like, no, we can't wait for the state Supreme Court to rule on this. We're going to vote her out now. And they voted her out of office. They kicked her out of office. But even after that, but now she's still sitting court judge because the other judge hasn't taken over yet. So while she's still in office now, she went to a nightclub and got caught. And the police showed up for a fight. And she was charged with a felony count of fighting the police. She punched the cop in the face, wrestling with the police officers. So now she's under arrest for beating up the police, a sitting judge, fighting the police in the nightclub overnight. So that's where she's at now.
Nate, did you do any of her background, how she got into the judicial sector? I mean, so she was an attorney before that, and she ran for probate court judge. And when she ran, there was, because there's really not a lot of people running. So, she had the look, and the majority of that community happened to be Black. So she won that election. And even in running, she ran. So part of the complaint for her judicial complaint was that during her campaign, she would make videos where she would, how you have blackface? Well, she would actually go whiteface and dress up as a white man and pretend to be a white man giving Black women advice about dating white men. So it was like it got that. So that was even there where she was her racist campaign, but she won. And they voted her in. So that's kind of like a little bit of her background. Our coveted democracy.
I don't know. I just feel like her, Fonnie Willis, Tiffany Hinyard, would make just a phenomenal bowling team.
No, she is this woman is crazy. This woman is crazy. And again, which you guys can see the Facebook video of her pretending to be the white man in her campaign video. It's pretty crazy. It's pretty crazy. But
yeah, interesting comment there from Kurt. Was she a bar association member in Connecticut? But it's sort of an interesting pulling this full circle, right? Talking about conduct of attorney, like licensed attorneys and members of the bar, et cetera. And especially when you're held out as a judge, even if, I thought it was funny that she said, you're, shuffling papers, right? Probate court, you're shuffling papers. It's not that big of a deal. However, you are still perceived by the general public to be a judge, right?
Yeah.
And and even
ask Nathan Wade.
Yeah.
Deeply experienced judge.
Well, look, point being is that it's a coveted position, and it's perceived by the general public to be even more of an esteemed position than simply being a lawyer in most contexts, right? So I think it's interesting from that perspective. We're not sending our best, I guess.
Yeah, and I think also too, the local government there, they also have some stuff they need to they got to account for. There should have been no way that you should get a brand new judge to be the highest paid judge in the state just because she happens to be a female and Black. Like, really? Is that really what we're doing? And she's not even handling the same amount of cases. It's like 600 versus 10,000. Like, there's no way that any rational person, I believe, if you sit back and think about it, can say that's fair. But I think in this new world we live in, where we're trying to correct the wrongs of 200 years in the past, then now you can do things like that, and then
there are plenty of qualified people who deserve to get wages. Why is it these same grifters, and I'll call her a grifter, I'm sorry, everything she's doing, not paying her clients, things like that, feels horrible. Why is it these people who keep appearing versus all the other super qualified people that I'm sure you guys know?
Well, I think. But don't forget where we're at now. You got to remember where we're at now. We are at the time where it's not about your qualifications. It's just
we talked about a story several months ago. I think it had to be April maybe, when what was the story? And I'm hazy right now, but about the elimination of the LSAT, or was it the bar?
Yes. In Washington, we talked about it.
So again, I think to your point, Nate, I support exactly where you're going with this. There is, I think, Eric, you're ascribing a certain the existence of a certain level of competence en masse that may not exist in the market right now, because the education system has been under tremendous pressure, especially in the postdoctoral or the postgraduate world, sort of the law school world. Law school curriculums have shifted dramatically in the last couple of decades. And
I want to address this comment real quickly, though, before it gets out of hand. What do you mean, Eric, these people? Throw Michael Avenatti on the list, too. Okay? Will that clear things up for you?
Sure, but so point being that we should not be making the assumption that the existence of a bar license or a JD is anything more than a minimum standard of competence. And I think that the bar exam is famous for saying that that's all it is, right? State to state, passing the bar exam means that you are minimally competent to practice law. If education has shifted such that law schools are unable to reform sort of that cognitive process the way it historically has, so that you see things facts first and you apply law and you understand foundational theories of law and how things have evolved, you're getting a class of practice ready attorneys, right? Everything is very pragmatic and oriented towards service ready stuff. A Sarbanes-Oxley class of lawyers that are just very compliance minded, right? We're not necessarily talking about the same cohorts of new attorneys. And I say that as one of the members of a very young attorney demographic, right? I went to law school. I saw the writing on the wall.
Well, perfect shift. Let's go into incompetency. We've got Jeff here, legal.
Oh, hey, yeah. So that's why I came
during
here.
retrial catch up.
Yeah, I just you wanted to talk about incompetent people, so I thought
Hold on, but
I'm an
Jeff,
expert in that.
Jeff, don't forget to mention tonight because we're going to be on tonight, right? Today's Friday.
Yeah, we got my F it Friday stream here in about 7 hours.
All right.
Got a lot of work to do, man.
It's gonna be a stream heavy weekend.
Oh. All right. So, Jeff, you've been covering Karen Reed, I believe, right?
Yes.
And that case seems to be going on as long as OJ and providing lots of views and thrills. What is going on now? What is the latest?
I know what Jeff want to say, Jeff. Before you speak, she's guilty, absolutely guilty. She's going to jail.
Yeah, totally. Well, as of about
do your thing, chat.
2 hours ago, about an hour and a half, 2 hours ago, the Commonwealth finally rested on the 29th day of trial. And I figure if you can't say things in less than 28 days, that's a thing. And the first two defense witnesses have been awesome. We had like Mr. Plow, who was a snowplow driver. Guy seems to be heavily somewhere on the autism spectrum, where the guy he has like one of like the Rain Man type memory where he just remembers everything, and he functions on time schedules. He knows exactly where he was at exactly what times, and anybody that said it differently was a liar. And he came across very, very credible. And the second witness we just called her Dr. Mima. She's this expert specifically in police canine bites, and she's had two careers before a lot of people were born. She was a Massachusetts police officer for, I think she said 14 years, something like that. Then she decided, I really want to study medicine. So she did an intern in emergency medicine. A residency. First of all, she went to medical school. And then she did a residency in emergency medicine. Then she said, I really like pathology too. So she went and did a second residency in pathology. Then she went on to teach. Then she went on to be on the I believe it's the California Medical Board at some point. So she's like way overqualified. It's just like, yeah, those are dog bites. Those are dog bites on her arm. There's nothing else they really could be, is what she was saying. And the Commonwealth is really, really struggling with these first two witnesses.
Well, since you've watched the whole thing, from the parts I've watched, I'm going to say it doesn't seem like she should be found guilty. It seems like it's a crap show. How do you feel right now? If you're a juror, because you've watched the whole thing, you're a juror, would you be convicting this woman based on what the state put on?
I would be wondering how this thing even got to trial.
Yeah, it's that bad.
It just makes no sense whatsoever.
Question though, how much of that does a jury actually see? And I ask this legitimately because like we watched the whole Rittenhouse trial and we see everything that's going on. Well, the jury's not in the damn courtroom, I believe, the whole time. So if you filter it out and really look to what is being presented before the jury, can we ask you that same question again?
Yeah, well, that's kind of that's how I watch the trials. I try not to see too much before it goes to trial, and then I just focus on what is being shown to the jury. And there's been so little, and what the Commonwealth has put on has been so contradictory. They have one witness saying that looking at the data from her SUV that they downloaded shows that she put her car into reverse and ran her 7,300 pound SUV into this guy's face at 24 miles an hour at 12:45 a.m. But then you have another witness that just says, well, yeah, we have records of her connecting to her boyfriend's Wi-Fi at his house at 12:32 a.m. So you have these wildly conflicting things that they gloss over and they don't try to rectify. It's stunning how incompetent the prosecutor is in this case.
Is this one of those cases where the defense could have just said, I rest?
I think that would have been risky. Plus, I mean, oh my God, where do I even start? Their accident, the Commonwealth of Massachusetts accident reconstruction guy was, he had an associate's degree in administration of justice. He'd been a cop for a few years. And so he was a reconstruction expert. And he didn't understand physics. He didn't understand kinematics. He didn't understand basic geometry and math. And when he was asked, I think he was asked what the study of kinematics was, and he said it's about forward. That was that was literally his answer. But
like forward motion.
He just said no. It's about forward.
Okay.
Yeah, no. He was not a good witness. He was terrible. And in contrast, the experts that the defense are going to put on are two guys that they're biomechanic experts.
Mm.
I mean, to the point where apparently they did studies on the angle of the glass surrounding hockey rinks and analyzed the injuries that the hockey players were suffering when they got body checked into the glass. And they realized that if you tilted the glass a few degrees, it would significantly reduce injuries to hockey players. So just because of them, they basically reinvented the hockey rink. So I mean, these guys are really qualified. It's just, they're just making an embarrassment of the prosecution's witnesses.
But then, is there like a fear? Because sometimes it could be the fear of doing too much, right? If you're the defense and they haven't proven their case, obviously there's probably the motion and the judges denied that. That's what the defendants put on the case in chief. But you don't want to put on, because if you don't want to lose the case because you put on a case, right? So do you think there's any fear of that where the defense could, because right now you're saying they're winning. So is there that possibility where they put on too much and then it gets to the point where now you're back at even?
Snatching defeat from the jaws of victory.
I don't think they'll get to that point because I said they went 28 and a half days with the prosecution's case, and they're saying the defense says you're going to need about 4 days to put their case on.
Oh, okay.
Yeah. All right.
So
all right.
They want to have it to the jury by Thursday is their goal.
It seems like the prosecution in this case is hoping, because there's this way that the prosecutors always feel like if we put on a long case and a lot of days and a lot of evidence, it's like we'll win because people are like, well, if they're doing all this, these people have to be guilty, right? We were given 29 days and heard from all these people versus the defense. So that generally is helpful to the prosecutor, right? We've been on for 29 days. And it forces the jury to say there must be something here because they put on a 28-day case. So I'm hoping that fatigue doesn't get to the jury, and they evaluate the case.
I think it actually is going to work against the prosecution because to try to explain how he was hit in the face by a 7,300-pound vehicle and suffered no injuries at all below his neck. They put on 4 different experts talking about. Apparently, it was alleged that one of the people had texted how long it takes to die in the cold, at 2:30 a.m., like 3 hours before anybody knew anybody was dying in the cold. Mm-hmm. And they took 4 experts to explain why that timestamp was incorrect on her phone. So it's like one person can't do it. So they have to have 4 people to try to do the job of one person. And the lead investigator is one of the most horrific human beings that's ever walked on the face of the earth.
Trooper Proctor, right?
Saying that.
Yeah. I mean, he's just a filthy, despicable human being. And the jury makeup at this point, they've lost 2 jurors. The makeup, as I understand it, was originally 10 women and 6 men. So when you've got this guy saying, I'm looking at this woman's phone for nudes and I haven't found them yet, calling her the C word, calling her, flat ass, making fun of the fact that she's got the Crohn's disease and she has bowel problems. I mean, wow. Even the judge was disgusted with him, and she tends to lean pretty heavily in favor of the prosecution.
Well, Proctor's so bad that Ian Runkle, who's kind of a mild-mannered, Canadian, went on like a 5-minute rant, just trashing the hell out of Proctor about what a garbage human being he is.
Well, so did the governor of Massachusetts, who also happens to be a female. She came out and expressed her extreme disgust at him. Yeah, it was.
Why
bad.
is he on the force?
Yeah, well, see, that was what I kept saying. Is that notice when he's testifying, he's not testifying as former Trooper Proctor. He's still there. And part of the deal was when he was saying these horrific things about her, He was saying it in a group chat where his immediate supervisor and his supervisor's supervisor were in the chat. So
Yeah,
they were endorsing it. They were a part of it. It's not just him. It's several levels up.
thing.
It's institutionalized.
But just a lot of people don't realize that when you're in law enforcement, especially like local law enforcement, it's kind of a game of how long can you survive being there. And the longer you're there, the more experience you have and the higher you're up on the chain. So this guy who may be the worst there, but he's just in this position because he's been there for so long. He has all this experience and he may be bad at his job. And that's unfortunately, that's the institutionalized part of being in law enforcement, because you don't, like in the regular business world, if you don't perform, you get out. But in law enforcement, because you have a right to your job after you've been there for a year, they have to kick you out with due process. Those cops can just stay there and do bad jobs and you can't get rid of them until they retire. So unfortunately, unless he's breaking some law or do something like that, then they can't get him. So I'm thinking this is just somebody who's just been here for so long, who doesn't, I don't care. I can say whatever I want to the bosses. I can do this. I can be sloppy because nobody ever checks me. But now we got this big case. Now you get to see all of the problems that having someone like that on the force.
Is this another Derek Chauvin in the making?
Well, see, I think that's kind of what they tried to do, was to just say, look, we're cops, believe us. And I don't think they thought that she would fight back the way she's fighting back.
Yeah.
And now from day one, you have to explain how a police officer, there's a dead cop on the front lawn of another cop right across the street from another cop, from the lieutenant who's in charge of the detectives, how nobody came out of the cop's house to even look to see what all the fuss was about. When I don't know, if I'm not even a cop, and if there's a body on my front lawn, 5 emergency vehicles and a screaming woman, I'm going to come out and see what the fuss is about. But
yeah, that makes sense.
And the shoddy investigation of the death of a police officer, the shoddy way. The police station is apparently a mile away. They could go there to get stuff for things, but they couldn't go and get evidence collection. They're collecting evidence in red Solo cups. They collected blood evidence in 6 Solo cups that they got from the police officer, the lieutenant across the street. And
So wait a minute. Those Solo cups might have been used at a party in the house before that point.
Well, yeah, that's the thing. In these unsanitary Solo cups, with no idea where what they've been through. They put some snow with some blood in them in the Solo cups. Then they put the Solo cups inside of just a used paper grocery bag and took them to the police station and set them under the bumper of the vehicle.
They were trying to throw this case, it sounds like.
Yeah.
But hold on, did they not have a response team for like an evidence collection team or things of that nature? Because no. See, the problem is that I don't know how big this town is. If it's a very small town, they generally so people understand, if you're a small police force, which most police forces are, you get maybe like 5 or 6 officers or something like that. You don't have an evidence collection team. So what you would do is the county, you would have to call like the county to come to bring their evidence collection, or the state would have an evidence collection team.
They had my understanding is they did have the evidence collection team, but they didn't have a homicide investigation team. They do that through another department. But God, you've got this going on, and he's got all these marks and abrasions on his right arm. They took 2 swabs from his arm. 2. Only 2 swabs. And they put the wet swabs into a sealed plastic bag and sent them off to the lab. I mean, and then just there's ridiculous stuff that there was 1 7/8 inch piece of hair that was stuck on the rear quarter panel that survived being driven 60 miles round trip in a blizzard.
Wow.
I mean, it's just insanity. None of it makes sense. I can't imagine getting a guilty verdict on a 2nd-degree murder charge. Maybe I can possibly I would be able to wrap my mind around a some sort of negligent homicide thing. Just, I didn't know I hit it, but just to say that they had the mens rea to drive over her boyfriend and murder him because they had a little argument earlier that day is just ludicrous.
So right now, so in other words, you're saying that she almost from what it sounds like you're saying, she killed him, but the mens rea is just not there for second degree.
I don't even think she hit him.
All right, so that's
people,
that's even in jeopardy because that's what it sounds like you were
yeah.
saying.
Yeah,
a lot of people think the cops killed him at the party.
That's what I think happened. I think he got in a fight. His only injuries are a laceration above his right eye, marks on his arm, and a fracture on the back of his skull. But he was hit in the face with an SUV at 24 miles an hour and reportedly knocked 30 feet away into the snow in this guy's yard. But that's all he had. And the tail light supposedly fractured into 45 different pieces.
So how do you think he did die? Was it like getting in a scuffle and falling back and hitting a table or something?
Well, one of the police officers had a thing for Karen Reed. They were flirting a little bit by text, and he was thinking she was acting a little bit sus. I think there was a little bit of jealousy. They got into an argument, and they already said that the dog wasn't good around strangers. It was a German Shepherd, wasn't good around strangers. I think they got in a little scuffle. A fist is thrown. He gets hit in the eye. The dog joins in the attack. Somehow he falls back and hits his head on the floor. And they say, "Oh my God, we got a problem. Let's get him out of the house."
Did they ever search the house for blood evidence or anything else?
Nope. And apparently the Brian Albert that owns the home, of course, his brother's a police officer, and he's a police officer. His brother's not a police officer. Sorry. They refurbished the entire basement shortly thereafter. They filled in the swimming pool. They rehomed the dog, their dog of 7 years. They rehomed him suddenly, and they moved out in about 6 months. So it looks really bad, however you look at it.
Wow.
They never. That was one of the text messages. He was sending group text to his high school buddies, telling telling high school buddies he hadn't found any nudes. He was talking to his wife, talking to his sister, and talking to the other cops. And that was one of the text messages. His friends are going, "Oh yeah, so the owner of that house is going to be," and she's like, "No." He's like, "Nope," because he's a Boston police officer too.
Wow,
that was one of the texts they sent.
That is insane. Hold on. Let me get a couple of things here. Emil gifted 5 Laid Back Law memberships. Thank you very much. That really does help the channel out to get the word out there. And I'll be putting content will be behind the membership wall eventually as well. So people will get more bang for the buck. And Red Guy said 24 miles an hour in reverse, which is true. I don't know if you guys have ever tried to back up before quickly, but I don't know if I could drive 20 plus miles an hour comfortably. And then don't forget about the month gap between getting the evidence and it showing up at the lab.
Well, let's add one more thing to this. Well, a couple more.
Oh no!
This 24 mile per hour reverse was done by a woman who allegedly had a BAC of upwards of 0.24, somewhere around 2.21, 0.24, and it was 97 feet reversing in a straight line around a slight bend at 24 miles an hour to hit her boyfriend, who was apparently just standing there long enough to go, this is really interesting. There's a big, large vehicle coming towards me. I think I'll just stand here. None of that makes sense. And then, of course, Trooper Proctor was being the lead guy. He was the one that went and seized the vehicle. But the problem is, there's pictures, there's evidence of him getting the vehicle 90 minutes before he says he got the vehicle in his report.
Wow.
So apparently he had secret, unknown, unfettered access to this vehicle. And at the time of the accident, no evidence was found. None of these broken taillight pieces was found. Many hours in the afternoon, they found 6 or 7 pieces of the plastic, and they continued to find pieces of plastic on the front lawn. Other police officers continued to find broken pieces of plastic on the lawn for about 2 weeks after the accident.
Wow.
So they
had a search team, an evidence search team, scour the place the first day, and they apparently didn't find 45 pieces. They found like 6.
So a lot of concentration on finding taillight pieces, but not so much on testing wounds.
Yeah, well, and even in the videos they've shown of the vehicle, allegedly after the body had been hit, it looks like the taillight's intact to me. And two of the prosecution's witnesses said the taillight was cracked and there was a small piece missing from it, but it was not shattered. But then there's video of her backing out of her house to go find her boyfriend who didn't come home that night. And as she's backing up, she backs into his car with the right rear where the taillight was broken. So, I mean, as far as I'm concerned, that's where she broke her taillight.
Well, cool. Maybe this time next week we'll have a verdict, or it'll be out to the jury, and we'll see what happens. So,
go ahead. Sorry.
Oh, sorry. Go ahead, man.
I'm just amused at the people that anytime you say someone's guilty or someone's not guilty, it's like, yeah, you're either a bootlicker or you're on the opposite side of the fence. It's like, if she's guilty, I want her to go to jail. I want the guilty people to go to jail and get off the street. I want the cops to do a good job. I mean, literally.
Welcome to law tube.
Yeah, they have the power to take away your life. It's hold them to a standard. If they don't do it.
We've been taking these shots ever since Rittenhouse. Yeah. Because everybody was saying Rittenhouse is going to be found not guilty, and they were killing us for that. Matter of fact, I don't know how many bad names have been called for the whole Rittenhouse call. Because I called Rittenhouse early, and it was just like, oh my God, you're this, you're that, you're evil. You want to see black people get killed in the streets?
Yeah, of course you have. He murdered 4 black people. Come on.
Yeah. I'm like, he didn't murder any black people. What are you guys talking about? Where's this coming from? So, yeah, it happens a lot. So.
All right. Well, we'll definitely be tuning in next week. Hopefully we know more in the interim. Nate, what do you have going on? What's coming up?
So YouTube has essentially now, because I think I complained on Twitter about every time I uploaded a new video, it would be automatically demonetized. So I didn't know what the hell was going on. But now it seems like since I made a little noise, things have changed. So I have like a whole ton of videos in the backlog that I'm now get to put out, because all of a sudden this morning things turned green. So I'm very happy about that. But we got Tiffany Hinyard coming up. We got the mayor of Oakland, who's got the FBI raid. That's coming up. We got some more judges who essentially are just going insane. And I'm going to say this. Tiffany Hinyard in Illinois is crazy. But there's another judge in that same town who's pulling a Tiffany Hinyard also, just as crazy as she is.
A judge or a mayor?
A mayor. I'm sorry. Mayor of Harvey. Another mayor of Harvey. So yeah, but again, we got all these judges going crazy, all these mayors going crazy. It's going to be fun time. So just subscribe to the channel and you'll get to see all the stuff. And those of you who are members, you guys already see some of the stuff. So
good point. And Jeff, what do you have going on?
7 hours from now, we got the F It Friday stream. Just my drunken boozy griftathon we do once a month. Then Saturday evening, I'll be on Danny on Direct's channel with Flux, where we're going to be doing an unexplained stream talking about haunted and possessed artifacts.
Ooh. All right. Sounds good. Till next time, everyone, I hope you consider subscribing. Definitely check the people's channels out in the description. You can click there. It'll take you right to the channels. You can subscribe. It does help everyone. Good Logic didn't make it today. I hope everything's all right. But, folks, he's getting really close to 100,000 subscribers. So if you can, try to, go over there, and hopefully we can get him over the top really, really soon. He's been at this for 3-4 years now, and I think it would be amazing. But until then, everybody, have a fantastic